Good morning and welcome to the Historic Courthouse. We have two cases on the calendar this morning. Number 24 CF 425, Smith v. United States, and number 23 CV 413, Bell v. Weinstock, Friedman and Friedman, PA, et al. Counsel, are you ready to proceed? All right. Mr. Myers, good morning and welcome back.
Thank you very much, Your Honor. Good morning, Your Honors, and may it please the court. I'm Peter Myers on behalf of Mr. Aaron Smith. I hope to reserve 2 minutes of my time for rebuttal. I intend to argue two issues, this morning. First, that the trial court unduly restricted the cross-examination of the government's two key witnesses against Mr. Smith, Officer Anthony Catan, the only witness who testified that he saw Mr. Smith possess and discard the pistol, and the other key government witness, DNA expert Stephanie Hickey. My second argument, which I believe is closely related to the first, is that the prosecutors in their final and rebuttal arguments to the jury improperly expressed their personal opinions, not supported by the evidence, vouching for the testimony of these two same key government witnesses. And again, as I say, I want to argue to Your Honors that these are closely related issues. First, with respect to unduly restricting cross-examination. Although the trial court allowed substantial cross-examination with respect to Officer Catan's extensive prior disciplinary history, the trial court did not allow any cross-examination with respect to the police finding that he had, in a prior case, improperly not turned on his body-worn camera in terms of a confrontation with a prior citizen. The trial court said this.
Can you help me understand a little more directly the relevance there? As I read the transcripts, I saw the trial court viewing it as, well, the issue with the body-worn camera in this case was it didn't really pick up anything, not that it wasn't on, and that seemed to be the kind of basis. But as I read your brief and reply brief, you seemed to say that it went more towards trustworthiness. And is that really the objection that was being made below?
Yes, Your Honor, what you say in terms of this case is totally accurate, that he had punched on his body-worn camera and that it did record him following Mr. Smith. It did record him saying, "Stop or I'll shoot you," which, you know, he acknowledged is a clear violation of police general orders. But he had turned it on that the body-worn camera did not document that he visually it showed my client possessing and discarding, but he does say on the body-worn camera, Mr. Smith is discarding the gun, which is very different from the body-worn camera issue in the prior case, which that he didn't activate it promptly. And the defense attorney says it's relevant. The trial judge says, as Your Honor indicates, that this is not the same type of thing. But I would argue to the court that it is, as defense counsel said, highly relevant, because the whole purpose of activating police body-worn cameras, as is reflected in the actual police regulation, which general order, which requires activation to ensure the trustworthiness of the police testimony. And the main challenge, which was made by defense counsel to Officer Catan, was it's just not trustworthy. That even because it's not the possession and discarding of the gun is not reflected in the body-worn camera.
So how much were they really hamstrung in making that point? I mean, in closing, defense counsel makes an incredibly strong argument, going so far as to say, well, this is a reckless officer. And there's a lot of evidence, as you fairly acknowledge in your briefing. How much did this really hurt in the grand scheme?
Well, I would submit to the court, as defense counsel argued below, that under the Coles case, in which there a substantial cross-examination of the police officer is allowed, but this court held it was reversible error when defense counsel was not allowed to bring the full extent of the officer's disciplinary proceedings to the attention of the jury. So sure, Judge Howard, defense counsel was able to bring out a number of his prior disciplinary proceedings. I mean, it's an incredible example of a long history of police misconduct, for this officer. But again, in Coles and in this court said that it's essential that defense counsel be able to bring out the full extent of it. And this court actually found reversible error in Coles, where defense counsel was able to bring out a number of that officer's prior disciplinary proceedings, but was not able to bring out the fact that in one of those proceedings, the allegation was that the police officer had copied and colluded with the other officers by copying his police report, to make it consistent with the other officers.
So is it your position that this is essentially a complete foreclosure of meaningful cross-examination such that it implicates confrontation and Chapman error analysis? Or that, I mean, you seem to be conceding that a substantial amount of cross-examination was allowed. So is it your position that this was more of an abuse of discretion in terms of line drawing by the trial court?
No, I think this is a crucial question, Your Honor, that by excluding totally any cross-examination of this, and the standard, if this court does find a confrontation clause violation, the standard is not, at least we would argue to Your Honor, this abuse of discretion, but the standard, from Van Alstyne of that it has to be harmless beyond a reasonable doubt.
Right, but you say completely prevented cross-examination of this. And I mean, that's the question, right? I mean, that's where the rubber hits the road. If there's a single question that is stopped or prevented, or an objection sustained by the trial court, then of course there's a complete foreclosure of cross-examination on that. But if there's extensive cross-examination on the related subject matter, I mean, that's the question. So at some level of granularity, of course, you're going to have a complete foreclosure. But if the idea of Officer Gatton's trustworthiness, reliability, care, all of that was sufficiently explored by defense counsel, isn't that what we're looking at? Now we're talking about line drawing by the trial court that's in the abuse of discretion world.
Well, respectfully, Your Honor, I mean, I disagree with that. Of course, I mean, certainly there was a substantial amount of cross-examination permitted with respect to the officer's unreliability on other matters. But with respect to this failure to turn on his body-worn camera and also limiting his questioning with respect to his pending civil action where an individual died as a result of the allegation and it was collusion, I think the Coles case is the crucial case for this court, where everybody acknowledged that extensive cross-examination was allowed, but it was essential in terms of giving defense counsel the full opportunity under the confrontation clause to bring out all of that and make a more persuasive argument to the jury. I'm arguing that the Coles case is the definitive one here, and that even though agreeing with Your Honor that extensive cross-examination was permitted and he was allowed to then use that as a springboard to argue, was it harmless beyond a reasonable doubt to exclude these two things, the body-worn camera totally and some more detailed questioning about the civil action where this individual died allegedly as a result of his collusion with other police officers.
I'm not remembering exactly what counsel told the court in urging the court to allow this cross-examination. What did counsel say was the purpose, or was there a proffer of what counsel hoped to bring out through cross-examination?
With respect,
I mean, I think the brief suggests that counsel didn't utter the words corruption bias or anything like that. What did counsel say to the court in urging it to allow this cross-examination?
well, that it was relevant to his trustworthiness, which is, again, I think the heart of counsel's argument to the jury, that this police officer is just not trustworthy, that he failed to properly activate his body-worn camera in a prior case, which again that was a finding made by the police department. That's one thing he argued. Let me get his exact words here. And then with respect to going further, with respect to his the civil action, defense counsel argued, and this is cited in my brief, it's from the transcript on October 10th, 2023 at page 8, he said that allowing full cross-examination with respect to the civil action would affect defense counsel's word, quote, his tenure and status within the police department, which seems to be a classic cross-examination of bias, which is protected by Van Alstyne. So defense counsel, I think, the government is not saying he didn't properly object to these things. And that's my first argument with respect to the police officer, that he was allowed substantial cross-examination, but under the high standard for restricting cross-examination consistent with the confrontation clause, that it's the government's burden to prove it was harmless beyond a reasonable doubt, and that allowing this additional cross-examination wouldn't have, I'm arguing, strengthened defense counsel's argument to the jury. And that's with respect to the police officer. The similar argument is made with respect to the DNA analysis. There's two areas where the trial court restricted cross-examination of the DNA analyst, Ms. Hickey. The trial counsel sought to question her on two things. First, that the DNA report, which she submitted to the court, and it's before your honors, misidentified the crime involved in this case. The DNA report she
So
prepared.
can you point me to the record? Because this was something I struggled with reviewing this case. She testified that she didn't have any knowledge of the specific crimes. And it looks like, it could have been a clerical error from her copying from someone else's error, which perhaps that promotes the sloppiness that you're mentioning. But where does it say in there whether she actually wrote it or prepared the report? Is there somewhere in the record you can point me to? Because I just couldn't find it.
Defense counsel was not allowed to probe this area. It is not in the testimony. And in fact, the government argues that, it could have been she received misinformation, I guess, from the U.S. Attorney's Office. But I think I would say to you, either way, whether this error was made by her and it's her report, or she received inaccurate information from the U.S. Attorney's Office that it was a robbery rather than a gun charge, I would say that is a classic case where defense counsel can argue that one reason why you shouldn't trust this DNA report in terms of its reliability is sloppy keeping of regular business records, whatever the source was. Defense counsel was not allowed to pursue this, and so we have no record of, what did she get bad information, or did she misinterpret the information she got from the U.S. Attorney's Office? But I say, from my perspective, either way, this would be a classic argument defense counsel could have made, pursued well. Show me the records you received.
But I mean, even if that's true, is she the right witness to pursue that line of questioning with? I mean, she was an expert, right? Not a fact witness. And defense counsel conceded in the trial court that this particular error did not speak to the reliability of the DNA evidence itself.
Well-
So even if people had been sloppy before that, and even if this is relevant to that, how could she even speak to that?
Well, she could speak to whether she received inaccurate information or whether she had accurate information that it actually was a gun charge rather than a robbery, and she misidentified the nature of the offense in her official DNA report. I think defense counsel could have made a powerful argument that in terms of whether or not you credit the reliability of this DNA evidence, and defense counsel had other grounds to challenge it. She admitted that the computer system that was used to analyze this star mix, she acknowledged that in other cases, there have been studies which showed that it was inaccurately reporting false positives. She also—
Yeah, and I want to ask you about that, because a lot of this argument seems to me to beg a question that my former colleague John Fisher liked to ask, which was, so what? When I looked at that, even in defense counsel's closing, they admitted that the grand total of false positives was somewhere around 1%. If we looked at the numbers they were using, like 110 out of 10,000. Is that really that big a deal?
Well, it's relevant, and the other aspect is also relevant, because defense counsel brought out that to the extent that this was showing a match between the DNA from his personal swab and the DNA from the gun, defense counsel was able to bring out that the alleles didn't match. His personal allele had a 19 peak in it. And then the allele with respect to from the gun didn't have a 19 allele. So it was not a total match, and she acknowledged that.
But that was before the jury, right? I
Right.
mean, the jury heard that.
I'm agreeing with Your Honor, but I'm saying that there were questions which were raised about the reliability of her testing of the DNA sample, and to be able to say to the jury, another reason why you should question the reliability of this record kept in the ordinary course of business was they didn't even get what the crime was correctly. And that's another reason why you, ladies and gentlemen of the jury, should have a question beyond a reasonable doubt of if they reflected, as the defense counsel argued, this type of sloppiness in reporting what the crime was, even though it's true, as Your Honor asked before, and that didn't directly relate to the reliability of this DNA result, it certainly is I think, potentially a powerful argument that defense counsel could and should have been able to raise with the jury of, it's just another example of sloppiness with respect to keeping this a very important
I
fact.
follow your argument, but it seems to me a jury might well think, this is a scientist, the DNA expert, that this person doesn't have any responsibility for knowing what crime was committed. Indeed, it's probably better if she doesn't know what crime is committed. Her job is just to compare, do the analysis to see whose DNA is on the object that's been presented for analysis. So I wonder if it would have affected jurors in exactly the opposite way. I don't find it very persuasive that jurors would have reached the conclusion about sloppy scientific analysis from misinformation about the nature of the crime. What's your response to that?
Well, I mean, that's not impossible, of course, with respect to limiting cross-examination. Again, it's the government's burden here, Your Honor, to prove this was harmless beyond a reasonable doubt. And I would submit to Your Honor that, the jury could well have looked at it your way, but they also could have said, wait a minute, doubts have been raised about the reliability of this DNA testing result, and the fact that this examiner can't even get correct the nature of the crime might reflect on the sloppiness of the analysis she did. It might, just like my other issue with respect to Ms. Hickey, that the judge precluded defense counsel from examining, was that the largest part of her training for 5 years and her work as a DNA analysis was at the DC laboratory, which shortly after she left there, after working there for 5 years, it was decertified on the basis of systemic unreliability.
Wouldn't that have also been a great argument to prevent her certification as an expert in the first place, if that was in fact a concern? And I'm not saying that I agree with your opposing counsel's point that, oh, no objection was raised at that point, and so it's kind of lost forever. I imagine that, it's still relevant. It could be brought up, but wouldn't that have had its most impact there?
Well, that is one way it could have been raised, Your Honor. Of course, the government argues that no objection was made to her certification as an expert to testify. But I think the Roberts case, which we cite in our reply brief for 13, is the best answer I can make to that. Because in Roberts, this court dealt with a DNA analyst's expert testimony, which was admitted by the court. And then this court said that it was, even though she was admitted as an expert, it was a proper subject of cross-examination for the defense counsel to challenge the reliability of her decision. And that case was specifically in terms of giving an expert opinion when there was a multiple contributors to the DNA sample, which is what was in this case too, 4 individuals who were identified as the source of the DNA found on the gun.
But that's reliability or weight of her findings and analysis. This is, you're talking about her training, the quality of her training, which is only relevant to her qualification as an expert.
Well, but I'd say if her experience and for 5 years was at the DC laboratory, which was decertified for systemic violations of proper procedures and reliability of their test results. This could also go to, and the jury should have been informed of that this was her longest experience, even though it wasn't tested in this case at the DC lab, of course. But I think this is also analogous to the decision in Roberts, where this could also go to how reliable should the jury consider her in conducting this DNA analysis.
Let me ask you another analogy, just completely out of left field, and I'd love for you to tell me how it's any different. I played high school football with 5 people who went on to college and 2 who went on to the NFL. We were a terrible team. We'd often lose every game but one in a given season. Did that make them any less good at what they do? Like, should we have looked at the team's record and attributed that to them?
I take your Honor's point that that would not be fair to make that assumption. They're individuals, and they could be great football players, even though the team was a lousy, if I could.
We had a lot of heart.
And that's what I was a soccer coach. That's what I would tell my younger students, that it's playing the game and enjoying it is what's important. But I don't think it's unfair to say that if the greatest experience he had in terms of time, 5 years, was working at a lab which was found to employ systematically unreliable procedures which could not be trusted to come up with reliable results. Let her explain that why that should not apply to her and why she was somehow different from them. And again, with respect to this type of cross-examination, I think the standard is so important here is that's not my burden to show that the jury would have found this credible. It's the government's burden to show beyond a reasonable doubt that it wasn't harmful. And I think these errors were also magnified by what the prosecutors did in final and closing argument. With respect to Officer Gatan, the prosecutor says, without any justification in the record, that, yes, the body-worn camera documents that he did say to my client, stop or I'll shoot you. And the prosecutor then argues to the jury, presumably in an attempt to humanize Officer Gatan, that I'll bet he regretted it. I'll bet he regretted it. And there's no evidence whatsoever to support that vouching for Officer Gatan's testimony. And the same thing with respect to Ms. Hickey, where the prosecutor says, in final rebuttal argument that, she came in here and said that it had a probability, but in fact, it's certain that it was a match here.
Well, I'm not, I mean, that's the problem, right? We're not, nobody's really sure exactly what the prosecutor said. I mean, we can read it, but no one really knows exactly how it came out or what they were trying to say.
Well, I wouldn't disagree that it's not, the language, which let me quote to you, that Your Honor says that this is the prosecutor's argument. She is not going to come in here and say 100% match. That's what it is, right? I think the message that is much more likely than not sending to the jury is, even though she didn't say it, that's what it really.
Yeah, but isn't inflection important? She's not going to come in here and say it's 100% match. That's what it is, right? She's not going to say what I just said, that it's a match. I think it's really ambiguous, and you really can't tell from the written page what the prosecutor meant. And in my mind, what's really significant is that people didn't react to it at the time. Defense counsel didn't jump up at the time and say, arguments going beyond the evidence.
Well, and that's fair, Your Honor. It's the difference between my first argument with respect to unduly restricting the cross-examination of the government's 2 key witnesses, which under the confrontation clause, the government has the burden of proving beyond the reasonable doubt was harmless. And with respect to this comment, which is on the other extreme, Your Honor, since defense counsel did not object to this, that, I have the much higher burden of proving a plain error. And again, unless the court has, I see I'm way over my time already. Unless the court has any additional questions, I'd be happy to reserve, the rest of for a brief rebuttal if necessary.
Thank you, Mr. Myers.
Thank you.
Ms. Gabriel, we'll hear from you now.
Good morning. May it please the court, Elizabeth Gabriel on behalf of the United States. The trial court's cross-examination rulings in this case were not an abuse of discretion. The court allowed ample cross-examination on a wide range of topics as to both Ms. Hickey and Officer Gatton. And I will first address Officer Gatton and then move to Ms. Hickey. With respect to Officer Gatton, particularly on the question about the body-worn camera, the late activation of body-worn camera. The trial court here did not err in determining that that question was off subject or irrelevant to the proceedings in this case. And no proffer was made by defense counsel as to its relevance. I would like to point the court to the discussion of this topic, the proffer that, well, the part of the transcript where we can see that no proffer was made. It was on page 67 of the October 10th transcript. The discussion is very brief. Counsel asks for to be able to question about the late activation. The court asks, was it sustained? He says yes. She says the body-worn camera is off subject here. He says, so out. And she responds, out. And that's the extent of it. And I think when we contrast it with the very next topic that was addressed, which was a request to question the officer about a failure to report damage to a police car, it's pretty evident that the body-worn camera lacked relevance and defense counsel didn't press the relevance of that topic, because on the failure to report, the discussion, this is on the following page, page 68, counsel asks to be able to question about the failure to report. The court says it goes to veracity, so that would be permissible. And counsel says, okay, exactly. That's in fact true. So, and then counsel closes out by saying, body-worn camera out, car accident failing to report in. I got you. Thank you, Judge. So just based on the transcript alone, we could see that counsel really didn't proffer any basis for the relevance of the body-worn camera question. And it's whether based on corruption bias or impeaching credibility, there's no reason to believe it would have been relevant to the facts of this case and the cross-examination of the officer here. But in any event, even if the court should have allowed some sort of questioning on that topic, it is very difficult to see how it would have made any impact or had any impact on the jury's evaluation of this officer's testimony when he was so thoroughly cross-examined on a litany of disciplinary matters, the civil lawsuit that was pending, and was asked point blank by defense counsel, wouldn't all of these proceedings, all of these disciplinary matters and the civil suit impact your career? And the officer says, yes, I believe that to be the case. So he got the point out that he wanted to make, and then he forcefully argued it in closing argument as well. If there are no questions about that, I can address well, just one other matter, the civil lawsuit, just to address one point that was made on that. Mr. Smith argues that he should have been allowed to go into the facts of that case. And I think it's clear from the transcript that defense counsel was able to elicit the import of that case and the facts underlying the civil suit. All of that came out. And again, all of that was presented and very forcefully argued to the jury as a reason to discredit this officer.
Did they get the point out about, colluding to cause it to happen, like coordinating with another officer?
Yes, that was elicited. And counsel had proffered to the court that he wanted to bring out the collusion aspect of that. The court agreed, and that was what was presented to the officer. So that all came out before the jury, and as well as the fact that the suspect had actually died in the crash, which was important. The defense counsel's argument in closing that this was a reckless officer, one who was, had a pattern of disregarding safety protocols.
And let me pull you towards a more global point. And not asking you to regurgitate the point from your brief, but basically Judge Shanker's question to Mr. Myers, I'd like to pose to you as well in slightly different form on whether we're in Chapman or Kadiakis world, which I understand is your position that we're in the Kadiakis world. But what level of granularity? Like, I think it's clear you don't think this level of granularity in this case for the denial would move us towards Chapman. It hypothetically, what level would? If there was a categorical denial of a type of this, a subset of the different incidents and things that defense counsel wanted to bring, would that be enough?
It's always hard to answer a question like this because so much of this kind of topic is fact specific. But I do think in this case, you know, the exclusion of a single question, as Judge Schenker pointed out, doesn't move us into the constitutional error territory. I mean, here, counsel was given wide latitude to cross-examine on bias, on topics that would affect veracity and credibility. So we're, I think, very far from that line. Of course, yeah, that line could be crossed, for example, if the court didn't allow any questioning about the disciplinary matters at all, because I think there's a good argument here that, well, some of them do maybe reflect on his credibility or potential bias. But that's not what happened here. I mean, the cross-examination was very extensive on these matters. And so, you know, when we're talking about line drawing, where we're talking about excluding evidence that maybe is not relevant or is only marginally relevant, this court has said that only marginally relevant questioning, where ample questioning has already been permitted, does not take this into Chapman territory, and it's subject to Kodiakos instead. Okay, I can turn to Ms. Hickey, unless there are further questions about Officer Gatton. With respect to Ms. Hickey, I just do want to point the court to the transcript and the discussion about the cross-examination on the report of the offense, how it was recorded in her report. Because I think it's important to note that when the court asks, and this is on page 91 of the October 6th transcript, when the court asks defense counsel, what relevance is it as to what crime or offense? Defense counsel responds, in terms of the scientific evaluation, none. But in terms of the general reliability of what was communicated, and then he says, I assume it was MPD who sent this over. Then he says, the fact that they have an incorrect offense level shows some slovenliness in their reporting. So counsel is trying to show that essentially that MPD was somehow sloppy in its reporting, but this was simply not the witness to do it through. Ms. Hickey didn't have any basis of knowledge of the offense. And that, the report of the crime in her DNA analysis was hearsay. She just really, she had no basis to say what in fact had happened or how she even received this information. And she made that clear to the jury.
Can I ask a factual question? I could have asked Mr. Myers this, and I should know this, but defense counsel wasn't permitted to explore this with her, but did it come out in defense closing argument that there was just the bare fact that there was a misstated offense on the DNA report?
I don't think so. And it probably wouldn't have been appropriate because he wasn't able to cross on it. So
Well,
I think that came out.
no, but I mean, the report was in evidence and everyone knew, and it was a fact that it wasn't a robbery offense. I don't see why that would have been precluded. But even if he hadn't
Right.
been allowed to explore the reasons with Ms. Hickey, seems like it still could have been flagged for the jury that, look, you've got a DNA report here with the wrong offense on it. I mean, it seems like the trial judge could have let that in, but anyway, I was just wondering if that happened or not, but.
I don't think it happened. And I think that that's actually the fact that it didn't happen is a pretty good indication of its lack of significance to the defense. Because the closing argument was centered on two things, which was the lack of credibility and the lack of trustworthiness of Officer Gatton and the alternative theories that would explain the DNA evidence. So this mistake in reporting the offense in the DNA report really did not have significance to the defense theory. And I think it's pretty telling that it wasn't pressed before the jury. And of course, based on that, we would argue that it was harmless, even if it was error to exclude it. As to the question about DFS's loss of accreditation, the trial court did not abuse its discretion in precluding defense counsel from questioning Ms. Hickey about that. Number one, because as the court fairly recognized, defense counsel did not voir dire the witness and had explicitly said he did not wish to voir dire Ms. Hickey, and had accepted her as an expert and did not raise an objection. And secondly, and almost more importantly, the court recognized that this line of questioning could be confusing to the jury because none of the evidence in this case was tested at DFS. There was no proffer made by defense counsel that Ms. Hickey had worked at DFS at a time when they weren't using appropriate procedures, nor was there any evidence or proffer made that Ms. Hickey had used substandard procedures either at DFS or in this case, more importantly.
But I mean, isn't there a potential argument that, okay, fine, you're an expert under the bare minimum required by Daubert, and we don't object to that, but, and I don't mean this personally against Ms. Hickey, but the argument would be, you're an expert, but you're not a very good expert, right? And you're not a very good expert because your training was very bad. And your training was bad because the place you got trained got shut down later. I mean,
Bad
that's
coaching.
the argument, right?
Right. And I don't mean to suggest that questions of that sort could never be asked outside of voir dire. I think that certainly that could be an appropriate topic for cross-examination. But here, going back to Judge Howard's analogy of whether we can, impute the poor performance of a team to a single individual, there's no proffer made here. Defense counsel simply didn't proffer a reason to believe that the loss of accreditation at DFS was relevant to Ms. Hickey and her experience or to the facts of this case. And without that proffer, I think the trial court, we can't say that the trial court abused her discretion. Could she have used her discretion to allow the questioning? Perhaps, but certainly it was not an abuse of discretion here. And even if we think that this should have come out and the judge should have permitted the questioning, there is just no reason to believe that this jury would have been materially swayed by any such testimony about her time at DFS, where, Ms. Hickey was thoroughly cross-examined on a number of, scientific articles, alternative theories about the DNA evidence. There's no reason to believe it would have undermined the verdict in this case. The last thing on closing argument I want to address is the comment, well, the two comments, one about Officer Gatton and whether this was vouching. I think it's clear by looking at the context of the comment here that the prosecutor was merely responding to the attacks on Officer Gatton's credibility and had, when the prosecutor made this comment about, well, I bet he would have regretted it, he then follows it up by referring to the testimony itself. He says he admitted that it wasn't proper. So I think that the jury recently would have taken this not as an expression of personal opinion, but rather an inference from the testimony that this is how this officer probably felt about it.
Mr. Myers says, though, that the effect was to humanize the officer. And that could have been important to the jury. So why is it not a problem?
Well, I don't think it's error to humanize a witness. I think that the parties are well within the bounds to rehabilitate their witnesses and to comment on the credibility, on the evidence which supports the credibility of their witnesses. And here again, the prosecutor was responding not only to attacks on Officer Gatton's credibility based on his prior record, but also this argument that was made that he was fabricating a story on body-worn camera. So this response was directly to those arguments. The fact that nobody seemed to notice that this was improper, nobody suggested it was improper, is telling as well. If this had been particularly egregious, defense counsel likely would have objected or the trial court would have noted it. So the absence of that, of any objection or any notice by the court, I think is telling as to the, the lack of the propriety or impropriety of the statement. With respect to the statement about the DNA evidence and whether it was a match, I think we would agree that this statement was ambiguous. The prosecutor makes very clear and actually quotes directly from Ms. Hickey's testimony because he wants to be precise about what she said. So he quotes the likelihood ratio exactly as she said it. And then he says, she's not going to come in here and say it was a match. That's what it is, right? Hard to know what that means, but I think if we can glean anything from it, I think it's reasonable to view it as simply a comment on the strength of the DNA evidence. It was exceedingly strong. It was a very high likelihood ratio. And the prosecutor returns to Ms. Hickey's testimony and says that, she characterized this as very strong DNA evidence. So, and then of course, that is any doubt or uncertainty is then cleaned up later on in rebuttal, not only in defense counsel's closing and then in the prosecutor's rebuttal, where he emphasizes again, we're not saying this is a match. Ms. Hickey never said it was a match. In fact, she was cross-examined and questioned extensively on whether she could even use that term, and she declined to do so. So the jury was well aware that a match was not the evidence in this case, and that Ms. Hickey did not purport to find a match. Okay.
And actually, if I can ask you, before he
Sure.
corrected himself on the next page of it, he actually understated the match, right? He said trillions and then caught himself a few paragraphs later and was like, actually, we're beyond billions and trillions or in sextrillions, or he said whatever comes next.
Right.
Is that right?
Right. So, I think it was pretty clear that he was commenting on the strength of this evidence and not expressing a personal opinion or attempting to argue evidence that wasn't already before the jury. If there are no further questions, we would ask this court to affirm.
Thank you, Ms. Gabriel. Mr. Myers, you reserve some time.
Just very briefly, Your Honor. We would submit to the court that the proper standard of review is the Chapman standard. With respect to Officer Gatan, the trial judge excluded any testimony or cross-examination with respect to the failure to activate his body-worn camera in a prior case. And I think this, clearly would go to the officer's trustworthiness, credibility, reliability, and the jury was not able to hear this aspect of his prior disciplinary proceeding. So that, and then even with respect to the civil action, the jury was able to hear it in a general way, what he was accused of doing. Classic bias, cross-examination with respect to, he acknowledged himself, his, ability to continue to serve as a police officer was not allowed to go into the details, and that, so this was, a substantial restriction on the cross-examination, which would trigger confrontation clause. With respect to the government's final argument, with respect to Officer Gatan, the government counsel argues it was a reasonable inference from the evidence. If it was, well, then the government could fairly make this argument. But I would submit to the court that it clearly was not a reasonable inference, that he regretted it just because he acknowledged that what he did was a violation of the police general orders, that you can't threaten to shoot somebody as they're, heading down the street. It was not. I think that's the key point here. This was certainly defense counsel and prosecutors always try to humanize their witnesses. That's fair if it's based upon the evidence. But I think the crucial thing here is that, especially given Officer Gatan's prior history of not really regretting violence and other infractions against citizens or suspects, there was no basis for the prosecutor to characterize that as, I'll bet he regretted it, which he repeats twice, I'll bet he regretted it. So that if it was not a reasonable inference, which the prosecutor was now saying to the jury, vouching for the credibility and humanity of this police officer, when it was just not justified, we would argue from the record. With respect to Ms. Hickey, again, the fact that she might have, which defense counsel was not able to pursue, misreported the nature of the offense in her DNA report, whether to be able to ask her, did you get that misinformation from the U.S. Attorney's Office who messed up? Or did you get the correct information that it was a gun case and put down robbery as mistakenly in your DNA report? I think defense counsel, if allowed to ask that question, could have forcefully argued to the jury, this is just one more reason why, if she can't correctly describe the nature of the offense in this case, or misreported it from the information she had received, or got misinformation from the U.S. Attorney's Office, either way, if defense counsel would have been able to pursue this, it could have been a powerful argument to the jury.
I mean, don't you think defense counsel, following on my question to Ms. Gabriel, could have still made that argument in closing?
Well, not if the trial court says, that's an improper question. I think the defense counsel, Your Honor, would have run the risk of the judge or the prosecutor objecting to say, wait a minute, Your Honor, objection. She was specifically precluded from addressing that question, and it would.
Yeah, we'll never know, and there's probably no point in going down this, but it seems to me, if it were me, I would have argued that, again, it's on the DNA report. The DNA report was in evidence. It's not a robbery. Sloppiness, even though the reasons why it got on there were not allowed to be explored with Miss Hickey. But anyway, that's neither here nor there.
No,
I assume you agree that didn't happen, right?
That's my understanding of the record, just like the government's. But again, by precluding defense counsel from asking the questions, I think a cautious defense counsel might have said, I do not want to run the risk of, in the middle of my final argument, raising this and the judge admonishing me. That's an improper argument. The risk, I'm not disagreeing with Your Honor, but the risk would be great that I don't know if a defense counsel would have taken the risk once the judge had clearly said you can't get into that in questioning the witness. Thanks so much to Your Honors, and would submit for all the reasons I've argued that the trial court should be reversed. It should be remanded with instructions from this court to allow appropriate cross-examination consistent with the Chapman standard here, because the government has not met its burden of showing beyond a reasonable doubt that allowing this additional cross-examination was harmless beyond the reasonable doubt. Thanks to Your Honors.
All right, thank you to both counsel. The case is submitted. We'll give you a moment to switch out, and we'll be calling 23 CV 413, Bell v. WEINSTOCK, Friedman and Friedman, PA, et al. Momentarily. All right, counsel prepared? Ms. Dennis, we'll call you first.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, Roddy Dennis on behalf of appellant Michonne Bell. I'd like to reserve 3 minutes of my time for rebuttal. Your Honor, below this court and the trial court below committed a few reversible errors, some of which are addressed in the court's prior decision in this case, where the court rejected the res judicata defense, the same res judicata defense argued by defense in this particular appeal. Specifically, res judicata fails for multiple reasons, one of which is defendants do not prove privity or a mutuality of interest in the in the creditor's 2017 lawsuit in small claims court. Second, with respect to the decision the decision below is contrary to the court's previous precedent in this case, where the court rejected privity based on the bare attorney-client relationship. Third, the collection agreement in the record does not actually disclaims any agency relationship between the creditor and the debt and the law firm, as well as disclaims any legal interest that the law firm may have in any amount of the debt or the judgment that was obtained in 2017 in small claims court.
Ms. Dennis, it seems like your res judicata argument is in some tension, unfortunately for you, with some of your merits arguments then, because to the extent, and I agree that, I understand that you can argue things in the alternative, but to the extent the law firm had no agency relationship and no shared interest with Fisk, then doesn't that undermine some of the substantive claims that where the complaint basically alleges that Fisk engaged in this activity? And so how is that attributable to the law firm if it wasn't acting in sort of that agency capacity, but was simply acting as a law firm in terms of filing a lawsuit?
Well, the law firm is also a debt collector, as my client alleges in the SAC. So they were acting, they did specific things on their own, standing alone, that actually violate each of these, not the creditor. The creditor actually did some things themselves, but also the law firm itself did things on its own, like, filing the verified complaint, when on the face of the complaint shows that the debt is not owed. Not filing all the, filing the lawsuit, knowing that all the mandatory notices are not actually included in the complaint, and did not file the notices in the complaint, yet verified that the amount is just and truly
But I
owed.
mean, is that, sorry, is that how you are characterizing them as debt collectors because they file lawsuits at the tail end of debt collection proceedings, or are they separately? I'm actually asking, are they
Right.
actually debt collectors in some?
They are separate,
way?
they are debt collectors in and of themselves, standing alone independently outside of any, because they not only collect debts through litigation, like in Heinz, like the Supreme Court said in the Heinz case cited in brief, but they also collect debts through the phone by calling up consumers and say, hey, can you pay us this debt? You owe this debt, et cetera. So they actually collect debts from consumers outside of litigation as well as through litigation. So they are considered, Ms. Bell alleges that they are considered debt collectors in and of in their own right.
Does she allege that they did that with respect to her? Did they
Yes.
call her?
Yes.
Does she allege that in the complaint?
Well, she alleges that one of Bernice, that they contacted her and basically stated that she owed a debt. And they did that once.
Where in the complaint does she allege that? Do you know?
She alleges that, well, she alleges that during the,
I don't want to hold you up, so when you sit down from your argument, if you
Sure.
can find it and give me the answer, I'd appreciate it.
well, she alleges that the deficiency debt is barred, and that they sought the debt from her through litigation.
But she
as well
does
as
allege
contact-
that, and I think
Yes.
there's some question of whether or not that is a sufficient pleading. It's rather bare bones, but that's why I was very interested in the detail you just referred to, because I don't recall seeing that in the complaint.
She also alleges that they contacted her while she was represented by counsel, which is also a violation of a couple of the acts as well. So.
It doesn't say in what context, though, as I recall. So, I mean,
Right.
for all you can tell from the complaint, they called her after the lawsuit was filed and said, Remember, we're supposed to be in court tomorrow or something. I'm just making that up. It just doesn't say anything about the nature of the communication or when it occurred.
Right, and I mean, they did contact, I'm not sure, I'll try and find it, but I thought I actually included in there that, an employee of defendants, Baris something.
You may be right. I'm just not recalling it. So if you can find
and I
it when
may
you
have-
sit down.
Yeah, I'll try, that they actually contacted Miss Bell and attempted to collect the debt that way as well. Not to mention, as I said, with respect to Heinz, the litigation conduct in terms of serving the complaint, verifying the complaint, representing to Ms. Bell at the mediation that the complaint is, that the amount is actually owed, as well as during the lawsuit, actually in Heinz, this is considered litigation conduct, which violates the Fair Debt Collection Practices Act under Heinz v. Jenkins, which I believe I cited for the court. So even them serving the complaint, knowing that the debt was not owed based on the face of the complaint, stating that, knowing that they had not filed all the necessary and mandatory notices to obtain a deficiency judgment or amount, they went ahead and filed the complaint anyway.
So counsel, she settled that complaint, right?
That the complaint was settled, there was a settlement agreement signed and yes, in 2017.
And she was representing herself at that point, I understand.
She was pro se.
So, and I get that you're bringing these claims under a different statute, but why should we not consider that issue conceded when she never challenged that in the original action?
She never challenged.
She never challenged that, oh, well, they didn't serve me these notices. They didn't verify there's these issues with it. Why should we go back and look at that now when she had an opportunity at one point to bring it up?
Well, in this particular suit, this is against the law firms. So this is not against the actual creditor in that. So Ms. Bell was the defendant in the in the creditor v. Mrs. Bell. So she didn't have an opportunity to say to the law firms during that case that, the law firms were, as I said, she was pro se, so she did not have the opportunity to even speak to the court with respect to her claims, because when the mediation occurred, the agreement was signed and basically the law firms, or sorry, the creditor
So
could
we
actually
can say
obtain a
ability
judgment.
because she was pro se, but she could have, I mean, it seems like the kind of classic thing where in the federal sense, you would have filed a Rule 11 and said, well, they didn't do a sufficient investigation before they filed this, and they filed this erroneous lawsuit against me. Like, these things all seem like defenses that would have been available to her at the time. I'm not saying that completely takes her out of it now, but it was, as I was reading through your briefing, wondering, okay, well, a lot of this seems like it could have been an issue back when and could have been brought up back when, and why wasn't it?
Well, they were the attorneys. They were not parties to the actual suit. So in terms of Rule 11, I'm not sure, I'm not sure that in small claims court, I'm not sure we can expect the.
I mean, that would have been a sanctions motion, right? And so, but beyond that, if these were things that were barriers, if not having these notices meant that the debt wasn't collectible at all, if it was deficient, as you're saying now, that would have been a defense, whether it was small claims or anywhere else, right?
Well, I mean, obviously, it's a defense because Ms. Bell is alleging that the suit is barred. Ms. Bell, as a pro se, and most in small claims court, most folks who appear there are pro se. And that's why in small claims court, they don't apply Rule 13 where you have to do a compulsory counterclaim and that sort of thing, because it's sort of a relaxed, informal procedure where parties come in and they represent themselves. Ms. Bell as a pro se litigant with no resources at all, would not know how to actually challenge a law firm telling her under oath, swearing that she actually owes the amount that is owed. She doesn't know anything about Rule 11 or anything like that. So with respect to that, and the informality of the small claims.
Your point on the
proceedings, it's
equities
kind
is
of-
well taken.
Right. It would have been difficult for her without resources or knowledge regarding what the whole civil process is.
No, and I
to
get
be
that
served with
the
a
crux
lawsuit.
of your lawsuit is you're saying that these firms take regular advantage of this.
Routinely. routinely. As I said, this is a class action, so this happened on multiple occasions with respect to the same law firm, where they filed multiple lawsuits against consumers who typically do not show up or who are pro se
So where did you get that information from?
from the record. It's not,
I
I've
know it's
alleged
in
it, but
the-
it's
in the
not,
pleading.
right now I haven't received any discovery from defendants, but I've done, but in researching the case and researching before filing the case, the dockets as well as, show that multiple lawsuits were filed without all the mandatory,
I want to get back to your res judicata points, but since you're on this point about multiple lawsuits having been filed, I wonder if you have thought about how the Twombly-Iqbal pleading standard applies to class action allegations. Do you satisfy the pleading standard if all you say is something like they have filed multiple lawsuits based on false statements of deficiency amounts? And that's essentially what your complaint says, but it doesn't put any meat on those bones. It doesn't say, we spoke to Mary Jones and Mary Jones was sued by this law firm for an amount and it was not the right amount. And I spoke to Sam Smith and he was sued by them. And even though he had already paid, the kind of details that you might put into a complaint and then go on to say, and there are numerous others, we think there's a class. Do you satisfy, does your complaint satisfy the Twombly-Iqbal standard as to the class allegations?
I believe so. I believe that this was done more than, I said it was done to more than 30 consumers, which with respect, the same exact thing was done with respect.
But it doesn't say anything about 30 consumers, does it? It just says many
Well, it
complaints.
says, I believe what I allege is that, and we're not, we haven't done a class certification motion or anything like that, and that wasn't challenged by defendants, but with respect to the,
You say upon information and belief, the lawsuit has filed such verified claims seeking to collect barred deficiency debt from consumers. But you don't say who, you don't mention anyone.
Well, in 60, I also go on to say that the law firms failed to provide individuals with motor vehicles, whose motor vehicles were repossessed, containing all disclosures required by AFRA, whether the notices provided to individuals whose motor vehicles were repossessed are defective, whether the notices charged more than $100 as cost for retaking the motor vehicle, whether
Right, and I think those are the kinds of allegations that caused the trial court to say all you did was recite what the statute prohibits or requires. You're just sort of reciting things that could be missing, but you don't say it happened with respect to anybody in particular. And that's what leads to my question about the pleading standard. But the briefs didn't really address that. So let me go back to your res judicata point, because you started out by telling us that there was no mutuality of interest between the law firm and the creditor, FSIC. You said there was no agency relationship, they didn't have a legal interest. And all of those things, well, at least the agency relationship is so, the creditor didn't assign the accounts to the law firm, that is so, but I wonder if that's required for mutuality of interest. And so I wanted to ask you this question. If your client had sought an allowance to appeal the small claims court judgment and had been granted that and had appealed and had won and had gotten a judgment that she wasn't required to pay FSIC the deficiency amount that was the subject of the judgment in small claims court, what impact would that have had on the law firm? Would they have had to repay the money to their client, FSIC? Maybe you don't factually know the answer, but the agreement that's in the record, the agreement between FSIC and the lawyers that's in the record seems to make their payment contingent on actual collections. And to the extent there's no collection, there's no payment. Why doesn't that create a mutuality of interest in the subject of the small claims lawsuit? That's my
Okay, so-
question.
Okay, well, the subject matter of the small claims lawsuit is basically the law, at the time of the actual suit, the law firms had not collected anything. They had no interest in they had not collected any money and they weren't owed any money and owed any money by FI.
That's Ms. Bell's
FISC.
claim. They were never owed any money, right?
Right. So if they.
But she agreed. She entered into a
And-
settlement agreement. She says, I'll pay you this amount of money until I pay off this alleged deficiency. And if I don't pay, you can get a judgment. And that's what happened. They got a judgment for the deficiency amount, less whatever she had paid.
FIC did.
Right,
FISC did.
correct. FSIC did. And it appears from the agreement between FSIC and the lawyers who are parties here, that to the extent that that was paid, and it was paid, the record tells us, it was paid, they collected their commission on that amount of money. And the premise of my hypothetical was, suppose she had gotten that overturned, wouldn't they have had to repay the money? I'm assuming so. I assume you don't know that as a factual
Well, that would be
matter.
it.
But I raised the question just to say, why doesn't that establish a mutuality of
Well, that would
interests?
that's the agreement that would be between FISC and the law firms. That has nothing to do with Ms. Bell. In terms of whether or not. they
That
would
is
pay
true,
that
but,
back.
but didn't the law firm and FSIC have a mutuality of interest in the money that was at issue in the small claims lawsuit?
Well, it's not they had the opportunity to obtain, collect a commission if they collect any amount of money, but that didn't vest until after they collect the money. At the time of the suit, there was no legal interest in the subject matter of the risk, the RASC, or the settlement agreement. And the settlement agreements clearly does not mention the law firms at all. And the the defense doesn't claim any interest in the contract, the RISC. So in terms of any interest that they may have vested, that may have come later after they collected an amount, like, along I don't know how long it took for them to, it was maybe about 8 or 9 months. I'm not sure how long it took for them to collect the entire judgment. But that didn't come until each time they collect the payment, they get a certain amount. At the time of the suit, which was a breach of contract suit, where FISC sued Ms. Bell for breach of contract, that's the subject matter of the suit. The law firms have no interest in the actual contract that was at issue in the 2017 suit at all. That is the basis of the suit. It had nothing to do with their side agreement to pay of FISC and the law firms to pay commissions to the actual, to the law firms for any amount that they collect. They didn't have to file suit. They could collect by calling Ms. Bell up, which they did, or contacting her outside of the law and collect, ask for payment of a certain amount. So the lawsuit itself, the small claims suit, was not, the subject matter of the small claims suit was not the actual law firm's commission to be paid if they, collect its side agreement with FISC. The lawsuit was about the RISC, the contract between Ms. Bell and what was alleged in that suit, Assanee, FISC, the creditor. So there was no, at the time of the suit in 2017, the law firm had no interest in the suit at all, no legal interest in the suit at all, nor could they, and they had no.
I'm just not sure that's the point in time when one applies the mutuality of interest test. I hear what you're saying, and what you're saying is certainly correct, but they certainly had a mutuality of interest in the money that
Later.
was collected as a result of that lawsuit, and in that sense was the subject of the lawsuit. So I'm just not sure you're applying the mutuality of interest test correctly.
Well, it seems to me that it should be applied during the actual lawsuit, the subject matter of the actual lawsuit that they're using to as a basis for their race judicata.
Well,
defense.
during the lawsuit, there's no judgment though. So,
There was a
there's no,
settlement. There
nothing
was a judgment after. Right?
to which
Based on
race
the settlement.
judicata could even apply.
Well,
Well-
there was a judgment after based on the settlement agreement. So, which is not, also does not mention it, make any reference to the law firms at all, and the law firms has no interest, as the collection agreement says, as states explicitly, that the law firm, you can obtain no legal interest. You are not, I mean, with respect to being an agent, the collection agreement specifically says you are not an agent in any shape or form, except as a bare attorney-client relationship situation, where this court rejected in Bell.
We've
in the-
definitely said an attorney-client relationship may not be enough, is not
Right, so-
enough. There has to be some more.
Right, and the
The
collection.
real question is whether the some more is present because of the nature of the law firm's interest in
Well,
the
I mean,
collections. And I just think it's not, the answer is not easy.
Right, and I would say, but I would say, if we look at it this way, I mean, if we can imagine law firms who file lawsuits on a contingency, who take on clients on a contingency type basis. A lot of law firm plaintiffs' attorneys do that. So can the attorneys, Ms. Bell, actually, let me ask you another question you made before I say what I was gonna say. With respect to the commission that you said, wouldn't the law firm have to give that back? They would have to give that back, not to Ms. Bell couldn't sue to get that commission that was paid.
Agreed.
They have to get that, FISC would.
Oh, I
So-
agree. She wouldn't,
So she would-
Ms.
there was
Bell would
general
not be looking
interest.
to recover from the lawsuit, from the law firm. But the point is that the law firm might have to repay that money
To
to
FISC.
FSIC, meaning that perhaps, at least arguably, it had the same interest in that money as FSIC did.
But Ms. Bell has no interest in that agreement.
I'm
at all.
not sure that's the test. The test is the mutuality of interest of FSIC and the law firm.
But it's also they're applying res judicata. So with respect to Ms. Bell, as a defense against Ms. Bell.
Well, the question
So-
is whether or not the law firm gets the benefit of the judgment against her in the FSIC suit.
Correct. Well, and as I'm saying, with respect to the subject matter of that suit, the legal interest, I mean, it's not the legal interest, there's no legal interest that is shared between FISC, as stated in the collection agreement, that is shared between FISC and the law firms.
Well, I'm not sure a legal interest is the test. It's a mutuality of interest.
Well,
We shouldn't belabor this point because I'm sure my colleagues have questions for you too, but I'm just thinking none of
Well,
the answers that you get out of the case law here is particularly satisfactory in this situation. So I'm not
Right.
sure on the res
I mean, the
judicata
subject-
point.
the subject matter is also different too. You're referring to the side agreement, and the actual the 2017 suit actually involved the RIS.
Well, I assume that because of the remand and the prior litigation, something about the relationship between FSIC and its lawyers was of interest. That's precisely what the trial court had to explore because the prior opinion did not say, no way is there res judicata here. It didn't say that. It didn't say we can foresee no basis upon which there could be a mutuality of interest here. Didn't say that either. It said, let's see if there is.
And typically when in other cases that I've looked at, there's some legal interest in estate and blood, as I think it's quoted in one of the cases of precedent of the court, of a legal interest in the actual subject matter of the suit.
And that may suffice, but the question is it necessary? I'm not sure that it is. I'm not sure the case law establishes that.
Right, what the one thing I was gonna say as well, which getting back to that, is that if we imagine that every plaintiff's attorney who sues a defendant on behalf of, obviously on the behalf of a client, if they are able to, I mean, if there's an interest there, can they then collect the plaintiff's attorney, can they then collect defendants, any judgment that the plaintiff may receive from the defendant as well as a creditor? Or can they just collect it from the creditor? It seems to me that and also with respect, I mean, I think it's sort of broad, the trial court's decision below really expands res judicata, because all plaintiff's attorneys work on a contingency, many plaintiff's attorneys work on contingency fee agreements. If it's just that, in terms of you get you have agreed to pay a certain percentage of your judgment to the attorney, then it gives that attorney, the attorney that representing you, a legal interest in the actual subject matter or the legal interest in the judgment, I think, and.
Well, you're back to the phrase legal interest again, and I'm not sure that's the test. But I'm sure, certainly not
Mutuality of interest,
suggesting,
to where-
yeah,
to where-
mutuality of interest. I'm not suggesting that the law firms could go and collect from the debtors in those cases. That's not what I'm suggesting. I'm suggesting that res judicata, their effect of res judicata arguably is that if the debtor is precluded from challenging the creditor's entitlement to the money, then she's also precluded from challenging, from asserting that the law firm has somehow acted on the basis of a deficiency that didn't exist or that was false or an invalid deficiency.
Yes, and obviously I take the opposite position with respect to that, because as I said, with respect to this being in a small claims matter, that Ms. Bell did not have, first, as I said, there are no compulsory counterclaims in
understand.
small claims court. So there's no way that Ms. Bell could have brought her claim against the law firms in FISC's small claims suit against her in that situation. So it would be, as I said, given the informalities of the small, small claims court procedures, et cetera, it seems to me that to actually impose this obligation of them to go and figure out any non-parties to the suit who may be implicated by the actual subject matter of the suit. It seems outside the scope of what the small claims rules intended in terms of quick and efficient, resolution of any particular claim. And it also.
Well,
puts a lot
I'm
of-
not suggesting that, because you'll recall in Bell 1, I guess we're calling it, the court didn't hold that none of the
Right.
claims could proceed. It held the claims could not proceed to the extent that they would nullify the
Right,
judgment, the entitlement to that deficiency amount.
right.
But there are other aspects to the claim. There are statutory damages, et cetera,
And
that don't go to that. And I
Right.
imagine those would still be available
Right.
as against the law firm too, unless they're precluded on some other basis.
Right, and but the situation is different from Bill 1 in that this is a non-party is what, and it's, I think and applying res judicata here to non-parties in a small claims suit by a creditor against mostly, as I said, people, litigants in small claims courts, except for the actual entities, corporations are typically, individuals.
So you're
mostly
arguing
litigants.
that res judicata perhaps ought to apply differently as it arises based on a small claims judgment?
No, I think that I would think that because it would make compulsory non-party claims against, unfairly so, make compulsory non-party claims that small claims litigant may have against some party that are not a party to the actual small claims suit. And the privity requirements under, res judicata are very distinct and, and limited, so as to not deny, litigants due process with respect to their claims. It's hard to imagine how a litigant, especially in Ms. Bell's situation would be able to figure out that who is not an attorney, she's not an attorney, the law firm is not, that the law firm is not telling the truth, know the law as to whether or not is, defense. And she, on the other side are lawyers who are actually, litigating the case, who should know better.
So is it enough to just be pro se, or do you need to be pro se and small claims?
Well, it's small claims and, it's an informal situation. It's small claims is there to quickly and efficiently resolve matters so that,
We have the same thing at the Office of Administrative Hearings, but we also consider that a court of record. And so things they decide and transcripts that they've made are applicable and could be used in other courts and could preclude things.
Well, the thing is that as I said, with small claims, they don't require compulsive, they exclude Rule 13 for a reason. And I think to now require res judicata is actually imposing a compulsory compulsory aspect to a small claim suit where you have to go and find all the non-parties to the suit and bring all your claims in that small claims action against all those non-parties. I think that would be unfair, given that the small claims rules already exclude Rule 13 or compulsory counterclaims as applying in that court. So to now apply and not have it apply, and that applies, Rule 13 applies only to parties. To now apply it to, apply a compulsory aspect of small claims to non-parties, I think is unfair to.
Well, I don't think that's what would be the result if your opponents are right. I mean, we've already established in Bell 1 that there are no compulsory counterclaims.
Mhm.
But the same opinion established that that Ms. Bell is bound by the judgment she got, or that the creditor got against her, that FSIC got against her. And it doesn't seem to be too large a step to say that anyone in privity with FSIC is in the same position. So we're just back to the question of whether or not the law firm is in privity. And as you know, the concept of privity has many tests in the case law. There are many. Mutuality of interest seems to be the common theme, and I'm not sure we've gotten very far in trying to understand whether that existed, but maybe we've exhausted that for today. So
Well,
I
yeah.
apologize for leading us off astray. I'm sure there are many other questions
Well,
to be
obviously,
asked.
my client's position, very strong position, strongly states, argues that it does not apply in this situation because their interest, they didn't have an interest at the time
Yeah,
of the
I
suit.
think I understand your position
And
on
given
that.
its litigation and it's a res judicata defense based on that litigation, not on other aspect, but that litigation itself, the defendants had no, legal interest in that of the type described in the court's precedent relating to privity and estate in blood and with respect to the rights that actually they would have to have in the subject matter of the first suit. Probably I've gone over my time, but
You forgot where you were, huh?
I also wanted to say that with respect to the CPPA claims relating to the attorneys being immune from the CPPA. Obviously, my client's position is that they are not, based on the plain language of the act, as well as, and debt collection is a trade practice under the plain language of the act.
Let me just be sure I understand. Your CPPA claim is in part based on enforcing other statutes, AFRA and the debt collection law.
FDCPA.
And are you still pursuing a sort of a freestanding CPPA claim
Yes,
too?
yes, because based on the misrepresentations relating to the debt, and also obviously the violations of, contacting her while she's protecting, represented by counsel, as well as other, I believe I list, misrepresenting her redemption rights, as well as failing to inform them, consumers of their redemption rights relating to the repossessions. And then, obviously charging more than the $100 that is the maximum amount that can be charged for retaking a vehicle. All of that is and that's in defendants, in the complaint, that's in the record. With respect to
Is your allegation, is Ms. Bell's allegation that the law firm itself was engaged in the AFRA violations?
Yes.
In the steps toward repossession,
Yes.
or the notice or lack of
And we don't-
notice?
Those are the allegations. We have not, as I said, Ms. Bell propounded discovery on the law firms 5 years ago, and she has not received a single piece of discovery from the law firm. So we are still trying to obtain how much they are involved in the actual repossession process. Right now, all we have are the notices filed with a complaint, which does not file all the notices.
Yeah, I was struck by the use of the passive voice in those aspects of your complaint, and sentences like no notice was given of whatever, as opposed to the lawyers did not give notice of something. So do you?
I did say that as well, and I believe I mentioned that. That defense law firms did not provide reasonably, reasonable authenticated notice.
Well, that may be something else you want to identify when you sit down and you can point out where in the complaint you suggest we look.
Right, right, and also that well, yeah, it's basically, just had it right here, so.
Well, let me ask you, Ms. Dennis, sorry. Your statutory argument about CPPA and legal services immunity, is that because the statute refers to the department not being able to enforce the statute against legal service providers, or is it because you are alleging that these were not legal services per
I'm sorry,
se?
I'm sorry, Your Honor. could
So you
repeat?
said that there statutorily, there is no law firm immunity, legal services immunity under the CPPA. right.
Attorney per se immunity.
Right. And I'm asking what the basis of that argument is.
That Ms. Bell alleges that the law firms are debt collectors, and they were engaged in debt collection at the time of the, and those are the allegations that she's making against the law firms involved debt collection and not professional services,
Okay.
which is a subject, which is what, the exemption actually covers, is the professional services of lawyers. So with respect to the, making false claims regarding the debt and, verifying the debt and that sort of thing, failing to provide notice, under AFRA, those and violations of Title 16 by charging greater than $100 for retaking fees. Title 16 is actually is actually listed under the CPPA as a deceptive trade practice. So they did all of those things are alleged by Ms. Bell that the law firms actually did them individually themselves.
Would you just repeat what you said? Something is actually listed as a unfair
Title-
trade.
Title 16
Mm-hmm.
is a deceptive trade practice. It's listed as under the violations of Title 16. Any violations of Title 16 is a deceptive trade practice under the CPPA. So that's also how it differs from Baylor as well, because Baylor is obviously involved just debt collection. This involves repossession and violations of AFRA, which was not alleged in the other case. If there are not any other questions,
I'm good.
All right, thank you. We still have your time reserved.
Thank you.
Mr. Ross?
Good morning, Your Honors. David Ross on behalf of the appellee, and just to clarify, it's one law firm. WEINSTOCK, Friedman and Friedman was the predecessor law firm. They merged with the Fram law firm in 2018. It became known as Friedman, Fram and Thrush. So this one law firm.
The law firm,
One law
right?
firm. So you understand
Right.
when I refer to a singular law firm, that's correct nomenclature. And I think it's important here just to step back momentarily and understand the contours and the context that bring us here today. So this case is by one individual against one law firm. And of course, the creditor, FISC, retained the law firm in order to collect an allegedly owed deficiency balance arising from a vehicle finance contract after the repossession of the vehicle in October 2016 and the subsequent sale. The only allegation alleged in the complaint, the only factual allegation alleged in the complaint that first is made against the law firm is when they filed the lawsuit. I think it's a plain reading of the complaint. And keep in mind, this is the second amended complaint, which means we've had 3 iterations already. So 3 different bites at the apple. You had the original complaint filed in 2019, you had an amended complaint, and then upon remand from this court, Ms. Bell filed a motion to amend the complaint yet again, which Judge Williams granted, and that was in February 2023. So we have the second amended complaint. So we have several iterations of the complaint already. So certainly plenty of opportunity to the extent that sufficient factual allegations would be alleged. They would certainly be included after 3 bites of the apple. And just a plain reading of the second amended complaint, which is the operative document at issue here today, shows that factual allegations, as Judge Williams clearly picked up on, are simply not there against the law firm. All the allegations specifically involve the law firm's filing of the collection case in Superior Court. And the allegation, of course, made by many, many litigants on the other side, we don't think the amounts you allege owed are actually owed. Not something, not unusual, certainly in the context of filing litigation. And what happened earlier in the case, of course, is after the mediation and the settlement, of course, and then, of course, the funds aren't paid as alleged, as owed, then, of course, the judgment is obtained. So Ms. Bell files separate lawsuits, one against, of course, FISC, the creditor client, the other against the law firm. And of course, the creditor, FISC, obtains a res judicata judgment. And this court says, okay, I mean, we'll agree that res judicata applies, but it doesn't impair the judgment as to the allegations before you went to court. So in other words, the allegations about the repossession and sale of the vehicle. Well, before that, so of course, before that decision is issued, this court, Judge Williams below, sees, okay, well, FISC got a victory on res judicata, attorneys are the agents of their clients, et cetera. So res judicata should apply here as well. And so granted dismissal. And then, of course, this court in Bell 2 says, okay, there are 2 different strains of thought here as far as res judicata. One is kind of your more generic, if you will. Attorneys privity with their clients, and res judicata applies to one, it should apply to the other. Otherwise, attorneys can be proxies for their clients and be sued when you couldn't sue the client. And that's the more generic, if you will, the more generalized strain. But then this court said, oh, there's other courts over here that kind of apply these separate tests. One is this mutuality of interest test. And the court in issue of first impression in its decision in 2022 said, we're going to adopt that position. So that's what's missing from the analysis on res judicata, because it was an issue of first impression. So there was nothing there for the court to address beforehand. But this is the test we think should be applied in the District of Columbia. So on remand, we need the court to make that assessment. Now, we're not saying that the case could be dismissed on other reasons. Certainly it could be, because the court didn't find a need to refer to those other arguments, because res judicata alone was enough to dismiss the case at the time. So upon remand, Judge Williams says, okay, well, I have this directive from the Court of Appeals. So of course, if you have other arguments to make, go ahead and make those in a motion if you want to test the veracity of the causes of action. And separately, let's see if this mutuality of interest test is met here. And so that's, of course, was much of the earlier discussion you had with my esteemed colleague on the other side is the mutuality of interest test met here. And the reality is, yeah, you're not going to find a case that says, well, it's definitely met here, because it's context specific. And there are 2 different reasons or 2 different avenues that really need to be met, we think, for the mutuality of interest test to be met. And we think they're both established here. But one is, what's the relationship at issue here? And as Your Honors picked up earlier, the relationship between the law firm and FISC was, it could have been an hourly arrangement. It could have been a flat fee arrangement, but it wasn't. It was a contingency fee, and you don't recover unless you actually recover in the underlying lawsuit. Well, the underlying lawsuit also has to have the right contours for it to apply. So in other words, if the underlying lawsuit was about whether the contract was valid, specific performance, well, they would have been mismatched there. That one would not have benefited the other, if you will, but it wasn't. In other words, injunctive relief wasn't sought. That would have been different. Specific performance wasn't sought. That would have been different. It was specifically about, do you owe a deficient balance? So in other words, if we collect, you collect. If we don't collect, you don't collect. That's the unique contours of the agreement, and that's the unique contours of the case at issue. So you have to have both of those meshing together in order for the mutuality of interest test to apply. And so it just so happens, under the unique parameters involved here, Judge Williams aptly recognized, yeah, when I look at the test and the contours of the test, and if there is mutuality of interest and there's a meshing of the interest in the outcome, it does apply here. It doesn't have to. There could be different circumstances, but in this particular case, it does apply. And that was the secondary reason that Judge Williams granted dismissal. Keep in mind, the threshold reason the judge granted dismissal was because, one, if you look at the complaint, there are simply no allegations against the law firm involving the repossession, involving the sale of the vehicle, not any that are set forth that are valid. You earlier mentioned Ashcroft, the Iqbal, and all the other, and Twombly, and those standards, they're simply not there. You can't simply recite assessments of what the causes of action require or conclusory allegations. Specific factual allegations are simply not there in the complaint. And so what Judge Williams wisely did was kind of walk through each cause of action first. Well, here's our threshold reason dismissal is proper. We know that Uniform Commercial Code allegations simply don't apply because the law firm wasn't involved in the repossession and sale of the vehicle according to the specific factual allegations in the complaint. Yeah, there's some conclusory allegations generically, but none with specificity that we can actually construe and interpret in applying a motion to dismiss. And so the court said, well, we know that, for one, the law firm is not a secured party to even trigger the UCC. Clearly not. And we also know that the duty of good faith, the other assertion under the UCC, well, it doesn't apply unless the statute otherwise applies. And the comment to the DC code specifically says that the duty of good faith does not support an independent cause of action. Kind of this generic, ephemeral duty of good faith that's floating out there. It has to be tethered, obviously, to something specifically that's set forth in the statute. And then Judge Williams wisely looked at the Consumer Protection Act, this CPPA, and said, well, look, I mean, here, the only allegations that are pled validly against the law firm involving the filing of the lawsuit, and yeah, you disagree with the amount set forth in the lawsuit. Well, that runs headlong into the actual statutory exemption for the professional services of lawyers, because you don't validly allege any other contact. Yeah, there's some vague allegation about you contacted me. There's no method, there's no time, there's no place, there's no means. There are no actual allegations in the complaint. It's just some sort of vague conclusory allegations. You represented me when I had counsel. Well, we already know based on the record that you didn't have counsel until the lawsuit was filed and pending for quite a period of time. So it also runs into the professional services of lawyers, which set forth in the DC code. And there's ample case law that specifies that. There's the Bergman case, the Banks case, the Petrangelo case versus Wilmer Cutler. And in fact, in the Petrangelo case, this court, it looked at Massachusetts and DC and compared the two laws and how they were in tension. So this court said the laws of Massachusetts and the District of Columbia are in conflict. Under the Massachusetts Consumer Protection Act, a plaintiff may bring a claim against an attorney who acts unfairly or deceptively in the rendition of legal services. In contrast, this court said, and that's, by the way, 68 Atlantic 3rd, and I'm citing page 714, under the CPPA, which specifically excludes attorneys, a plaintiff may not, in other words, may not bring a claim against an attorney who acts unfairly or deceptively in the rendition of legal services. And so the court picked up on that. And again, these cases repeatedly talk about it. Banks allowed the CPPA claim to proceed. Why? Because there in Banks wasn't an attorney. It was somebody who never graduated from law school and took the bar exam, who was masquerading as an attorney. And the court said, wait a second. You can't claim an exemption when you're not part of the exemption to begin with. You want us to, because you're masquerading as a lawyer, it obviously doesn't apply to you. And so the court said, yeah, it doesn't apply. And of course, we also mentioned that debt collection is not a trade practice. And of course, the Baylor case states that very clearly. So that's a separate prong that also supports Judge Williams' decision to go ahead and grant dismissal. And then, of course, we have the Automotive Financing and Repossession Act, AFRA case. Again, you don't have the triggering mechanism to have statutory liability because there's no allegation that the law firm was involved in the repossession or any notices sent involving the repossession. It was obviously the law firm's only involvement is filing the actual deficiency action. And so, and as an aside, AFRA doesn't prohibit the filing of a lawsuit over disputed deficiency. That's not the purpose of the statute. The statute is specifically about some sort of deficiency that you have in connection with the notice process, with the repossession process. And that's what the statute exists for. And so therefore, you don't have a cause of action under AFRA, or if it's enforceable under the Consumer Protection Procedures Act, you don't have either one there. And the court picked up on that. But the debt collection law, the court recognized, as this court did in Bell 1 against FISC, you got to have specific factual allegations here. And you don't. You just kind of had this general defendant unlawfully harmed me. And that's not sufficient here. You have to plead, and as this court said in Bell 1, you must plead factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And that's in 256 Atlantic 3rd, and the page site is 258. So this court picked up on that and it recognized that almost in a mirror complaint filed against FISC, that's just missing here, and that doesn't exist. And so that in and of itself was enough for Judge Williams to say, here's not enough. Now, admittedly, the debt collection law was amended in January 2023. That's when it became effective. And willfulness requirement was taken out. And so Judge Williams said, okay, I don't want to tread into that territory, whether I don't want to tread down, because I already find it's going to be deficient. But we raised the argument. And so certainly this court is certainly permitted.
So is it your position that even if there is no willful requirement, that the allegations were insufficient?
Great question. The answer is yes. We agree with Judge Williams that even absent a willfulness requirement, the allegations are deficient. But we also argue and we maintain that because up until January of 2023, the debt collection law did require substantial evidence of a willful violation, that because that does obviously impact the rights, substantive rights of the party against whom the allegations are assessed, that does affect your substantive rights, that the statute cannot be applied prospectively. It has to be, cannot be applied retroactively. It has to only be applied prospectively.
Is there a world though in this case where if the allegations are sufficient under a knowing standard or sufficient under a knowing standard, they would be insufficient under a willfulness standard?
Correct.
On the facts of being alleged here? In other words, what could your law firm have done, your client have done knowingly that wasn't also willfully in this case? I mean, I understand those two mens reas obviously have different meanings because otherwise they wouldn't be two different mens reas, but what's the daylight here?
Right. Well, one obviously includes an intentionality. So you had to intentionally present documentation to the court that wanted to defraud the court, if you will. And we wanted to engage in some sort of conduct that would be covered by the debt collection law to defraud or to trick, if you will, this plaintiff here, Miss Bell, into paying money that we know that isn't actually owed here. And we're going to engage in some sort of nefarious conduct to do so. And there's some evidence to back all that up. But that's what's missing here. And so one, you don't have the threshold allegations with sufficiency to even if you ignore the willfulness requirement that did exist until January 2023. But two, you need more than just, if you have some knowledge, but you didn't act upon that knowledge, that'd be one thing. But in order to act willfully, there's an intentionality there. And again, our argument certainly is it fails under both prongs, but both prongs are relevant. You don't need the willfulness prong to even be assessed unless you, of course, find that the threshold allegations were sufficient, but you can, of course, address it as an additional or independent reason to uphold the dismissal. And we're just saying that the general rules that statutes are not applied retroactively without clear legislative intent, and we simply do not have that here. And we cited in our papers as a strong presumption that legislation that impacts substantive rights will only operate prospectively. One example of that, the LASIK versus Washington Hospital Center case, and that's 978 Atlantic 2nd, 1194. And seeing my time is up, I'll quickly wrap up.
I have a couple of questions for you. Do you, leaving aside the legal services exemption, do you dispute that the CPPA reaches debt collection practices?
It depends on the context.
It
So
might reach debt collection
It depends on the
practices.
context in which you're discussing it. Here, I would argue no, because again, debt collection is excluded as a trade practice there. And so you have to really depend on the context in which you present it.
Where is it
So,
excluded as a trade practice?
that would be here. And I'm sorry, oh, with CPP, hold on a second, let me find it here. Oh, it's 28 3901, and that's subsection A6. And that defines, that's the definition of a trade practice, and that's what you need. Your linchpin, it has to be a trade practice. An act which does or would create, alter, repair, furnish, make available, provide information about, or directly or indirectly solicit or offer for, or effectuate a sale, lease, or transfer of consumer goods or services. And so you can see your circumstance where here, if I was a merchant or a vendor, I wasn't a law firm, and I was in the process of doing that. I was giving you the information about, or I was offering for sale. And then in the context of that, I'm also trying to collect on that sale. You can see how in certain contexts, yeah, you could have certain activities that would coincide with something that could be considered a trade practice. But specifically here, there's no offering to sell or provide plaintiff with any goods or services or provide information about something the plaintiff might be wanting.
What do you
to
think about
purchase or
this? I
sell.
mean, the AFRA regulations, AFRA itself, I guess, says that violations of it are enforceable through the CPPA. It has to do with repossession, debt collection. So why would that be enforceable through the CPPA if the CPPA doesn't cover debt collection?
Again, it depends on the context. Again, and obviously that's your secondary argument. Our first argument is, of course, it doesn't apply at all because of the professional services exemption. for
Right, I
attorneys.
get that.
But
right.
as a secondary argument, again, it depends on the context. It's context specific. So again, you could have circumstances where you might see it apply. But here, defined to the contours that are in front of the court now, it would not apply.
I mean, how would you reconcile what you just said, the context specific answer with that definitional answer you gave me before? It's not a trade practice because it's not a good or service. Yet it seems that in some contexts you could enforce a debt collection provision through the CPPA.
Right, again.
Still not a good or service, you might say, but somehow it's brought under the
Correct.
CPPA.
Yeah, it could have a certain specific linkage to a good or service. Again, it depends on the party specific and the specific activities involved. But the pure
You have an
isolated
example
act-
for me?
What
It's
comes-
probably not in your interest to give me an example, but do you have one of a context in which it seems appropriate to you that it would be covered under the CPPA?
Possibly, if you somehow link perhaps the repossession or sale with the purchase of another vehicle, and so there's some sort of a linkage there, and in connection with repossession, you're going to coerce plaintiff to purchase another vehicle, so you have some sort of a linkage there with a good or service. You could come up with hypotheticals, but they wouldn't be applicable here. I think you'd have to do some noodling in it, but I'm sure you can come up with hypotheticals that certainly would apply, because otherwise AFRA wouldn't be enforceable under the CPPA.
I have a different question for you. Let me read you one of the paragraphs of the complaint, and you tell me why it's deficient.
Certainly.
It's paragraph 33 I happen to be looking at. The defective and improper statutory notice purportedly pursuant to 16 DCMR section 340.2 and filed by WFF and FFT, I guess I'll substitute the law firm, and filed by the law firm, deprived consumers of their statutorily mandated rights were standard form notices used by the law firm in filing verified claims in District of Columbia courts. Translated to simpler language, I guess. So the notices that the law firm relied on in filing the complaint in small claims court was deficient. And the implication is, and the law firm knew it. Is that not sufficiently pled to pass the Twombly-Iqbal standard?
No, I don't believe
Why
it
not?
is. One, there's I don't see an allegation there that they knew it or how they knew it. Two, I don't see an allegation of any involvement other than attaching documents as all attorneys do when they're making filings from their clients. Attaching documents, that's simply not stated there at all. It's just simply, and it's conclusory as well. It doesn't explain how, why, when. It's just a conclusory allegation. So it's certainly not sufficient in order to emanate from that one allegation that there's some sort of an actionable cause of action here.
How about the
And
next
it ties
paragraph?
back in-
Many of the verified complaints do not contain notices of intent to repossess. and contained other deficiencies that prevent the alleged creditor from collecting the deficiency debt. What's your response to that one?
Those are it's the same response. It's cursory, it's conclusory, doesn't identify any specific, any specific notice, any specific debt, any specific complaint. It just simply makes a conclusory and cursory allegation there. And again, and keep in mind, the allegations here are this is an individual action brought by Ms. Bell. And so if Ms. Bell does not have an actionable claim, the class allegations are irrelevant. Because the claims rise or fall on whether you have a class representative who has actionable claims, because otherwise you can't meet the
Paragraph
standards.
40 says that the law firms issue notices to borrowers fraudulently misrepresenting that they're liable for deficiency balances, when in fact the law firm knows or should have known that as a result of the failure to comply with the provisions of AFRA, said borrowers are not liable for said deficiencies. What's wrong with that one?
Well, once again, that's a conclusory allegation, just mimics the language of a statute. It doesn't identify.
I mean, essentially, it says the law firm filed a complaint when it knew that there was not compliance with the provisions of AFRA. You think that one doesn't pass the Twombly-Iqbal
It does not,
standard?
because that might be a nice wrap-up allegation if it
Mhm.
was preceded by allegations that specifically had factual content. Because here, once again, you see that this is a nice conclusory allegation. If you have preceding it, allegations that actually identify how you have knowledge, which notices, which repossessions, how do you know, what was your involvement? So in other words, this is probably a textbook example of a conclusory or a cursory allegation that's not sufficient in and of itself. It doesn't provide notice of what the specifics are of your claim. It's completely divorced from that. It's just a summary allegation that needs precursor factual allegations in order to make it a viable claim. And that's what's missing from the entire complaint, are viable factual allegations against the firm in order for the complaint to go forward. Again, it's the third iteration. So there's certainly been enough bites at the apple, if you will.
Thank you, Mr. Ross.
If there are any further questions, we respectfully request that the judgment below be affirmed. Thank you, Your Honors.
Thank you, Your Honor. With respect to Title 16, it's hard to understand how a deficiency where Title 16 AFRA says that a deficiency is barred. And also AFRA says that the Title 16 is enforceable through the UDCPA, which is a debt collection law, as well as the CPPA, as well as the UCC. It's hard to see if there is no deficiency and a law firm claims that there is a deficiency, it seems to me that would, that debt collection, that is a debt, they're attempting to collect a debt that is barred with respect in violation of AFRA, since AFRA is enforceable through the CPPA, the debt collection law, and the UCC. So with respect to those allegations, I'm unsure how, with respect to defendants, I'm not sure how, I don't understand the statement, the argument that debt collection is not covered. Also, with respect to the CPPA, the trade practice, the definition provided, it's not just providing services, goods and services. You can also fall within the act by providing information about goods and services. That's also part of the definition of a trade practice. And that's what defendants were doing here, providing false information about a debt that is not owed.
But how is that a good or service?
I'm sorry?
How is the debt that is not owed a good or service?
Well, it's based on a credit sale, which is one of the listing, one of the
Right, but that's
aspects of-
the underlying transaction.
Correct. So with respect to the goods and services, it's regarding a credit sale. So the law firms provided information false information, she alleges, to Ms. Bell about a good or services that was that was the result of a credit sale. So they provided them, they don't have to actually provide the information, provide the goods or service themselves. They can provide information about the goods and services. And I assuming with respect to this situation, as I said, as Ms. Bell alleges, they misrepresented that she owed a debt with relating to a repossession, which Ms. Bell states that she did not owe the debt based on violations of AFRA, which she alleges as you know, them charging an 800 on paragraph 18, charging you know, $850 retaking of the vehicle fee, which they're only allowed to charge $100. This is filed by the law firms, and she says WFF and FT, the law firms charged $850 for the retaking fee. The explanation of deficiency letter also attached to the complaint states a charge of attorney's fees of $1,175. The complaint also states a charge of costs of preparing the vehicle of $701. These are all facts that are alleged. The notice of repossession shows the vehicle currently being stored at a location outside of the District of Columbia, which is, you know, in Maryland. The allegation that no notice of sale was ever provided to Ms. Bell, that's actually alleged in the actual complaint. So these are all facts that are alleged in the complaint that are violations of AFRA. And the fact that defendants actually were trying to collect amounts that are not legally, they're not legally able to collect with respect, especially with respect to the $850 and also the bar deficiency because of all the other the violations listed, that they misrepresented the amount of the debt. And that's a violation on its own, independently of the UCC, as well as the UDCPA or the debt collection law, the debt collection law. Also a violation of the Fair Debt Collection Practices Act, which does not require willfulness or any you know, intentionality or any other. It's basically a strict liability statute where you misrepresent the debt, you're liable, basically. So, and Ms. Bell alleges that they've also violated as attorneys under Heinz, where a litigation conduct of an attorney can actually be the basis of, you know, a debt collection violation, or is subject to litigation conduct. Litigation misconduct is subject to the FDCPA. And with respect to alleging her UDCPA claim, I would point the court to paragraph 100, where Ms. Bell alleges that the law firms violated each of the provisions above by misrepresenting the existence and the amount of the debt, filing false affidavit purporting to verify a debt. The law firms also communicated to Ms. Bell, knowing she was represented by counsel. They charged excess fees relating to the alleged debt and misrepresented the legal status of the debt, as neither Ms. Bell nor the putative class members owe a debt. And the law firms fraudulently filed a lawsuit in order to turn the bar deficiency debt to an enforceable judgment, which is a common practice. That so that they can both collect commissions on all amounts collected. Those are facts. Those are facts that Ms. Bell alleges in her complaint, and that's with respect to the UDCPA, as well as that's a violation of the CPPA based on misrepresenting a material fact. You can't represent a deficiency that's owed if it's not owed. That's a material fact. Ms. Bell would have changed her actions had the law firms told her, "Look, we violated AFRA. We can't collect this debt." She would not have signed a settlement agreement saying, agreeing to make payments on the debt if the law firms had revealed to her, told her what is that the actual debt is not owed because the deficiency is barred based on multiple violations of AFRA that also violate the CPPA, the UDCPA, and the UCC. Oh, also with respect to the settlement agreement drafted by the law firms drafted the settlement. They drafted the settlement agreement stating, setting up terms for repayment of the debt. So they changed. That's also a trade practice you actually altered the actual payment schedule for the debt. So that's another way that falls under the CPPA. Professional services. The defendants were not, Ms. Bell is not suing the law firms for their professional services. They did not provide any professional services to Ms. Bell with respect to, this is not a, a malpractice action, malpractice suit. This is a debt collection action. She alleges they are debt collectors. All we have are the allegations in the complaint. Ms. Bell has a right to prove that they are debt collectors, and they can be debt collectors and law firms and a law firm at the same time. Both, they can be both. They don't have to, not one or the other, they're not mutually exclusive. So with respect to her alleging that they're a law firm, they are a debt collector, just like the debt collectors in Heinz and Heinz v. Jenkins and other, other cases that are.
If all they did was file a lawsuit, would that keep them within the exemption for legal services? If that, I understand you dispute that that's all they did, but if all they did was file the lawsuit and settle the lawsuit, would they be exempt from?
No, they would not. I mean, basically, I mean, as I said, we have to receive discovery with respect, and there's a definition of what a debt collector is, and that, which is what defendants do. So with respect to, there's no legal lawyer exemption in the debt collection law at all. Anybody who tries to collect the debt on
So your line would not be drawn at something that required a law license to do or that we typically expect attorneys to do. Your line would be that debt collector goes into attorney duties as well.
A debt collector is a sort of proprietary business that some lawyers engage in. It's a debt collection commercial practice. So professional services, if Ms. Bell was here suing the law firms, if the law firms had represented Ms. Bell and were suing, and Ms. Bell was suing them in that capacity, then they may have a claim for professional services exemption on, under the CPPA. Ms. Bell is not suing the law. If FISC were suing the law firms for, violation, for bad legal advice, they cannot get an agreement. They cannot get they're exempt. The law firms services to FISC are exempt from the CPPA. Ms. Bell is not FISC. And Ms. Bell is a consumer who she alleges the law firm engaged in abusive debt collection, activities in order to coerce her into paying a debt that she did not owe.
Is her remedy for a violation of the debt collection law exclusively through the CPPA or
No, it is separate.
or I'm just not remembering, or does that law itself prescribe some
No,
remedies?
there are two separate claims, and as I said, there's no exemption in the.
So your point is that even, I mean, you don't concede this, but even if the law firm fell within the exemption of the CPPA, that doesn't protect them from an action brought under the debt collection law.
Correct.
Directly.
Correct.
That's your point.
Correct. And as I said, they don't, just, they don't fall under the services that she is.
I understand that you don't
Yeah.
concede that, but yeah.
Yeah, with respect to that. And as I said, with respect to, once we receive discovery, my client will prove that the law firms are debt collectors, and they don't actually deny that they're not debt collectors under, as alleged, under the, UDCPA, under the UDCPA. And they're also registered as a debt collection company in Maryland. So as a debt collection corporation in Maryland. So they can't deny that they have this whole separate proprietary commercial practice of debt, involving debt collection. So they are, and that's what, as I said, that's what Ms. Bell alleges that they are, as debt collectors, not as her lawyers are providing her with professional services.
That was the reason for my question to you about if all they did was file a lawsuit, because then they're being registered as a debt collection company. The issue becomes, did they act as a debt collector as to her, or were they simply providing legal services to the creditor?
And I would simply point back to Heinz. Yes, if you file a lawsuit, litigation misconduct is punishable under the FDCPA as debt collection. And they are subject to the FDCPA with respect to, because many times in situations where debt collectors will file a lawsuit in the wrong venue. So the defendant will not show up to actually litigate the case, and then they'll get an immediate, default judgment. There are all sorts of sort of inappropriate, illegal practices done, and those types of claims are covered by the FDCPA and the debt collection.
Do you have
laws.
the provision in your head?
For-
What section of the FDCPA would cover misconduct based on filing a lawsuit?
I
What's
don't
the
have it,
section?
I don't have it in my head, but it's, as I said, it's.
If you're like me, you can't remember numbers. I never have it
Yeah.
in my head, but I thought maybe
apologize,
you
Your
did.
Honor. You know what, actually, no, I don't have that here either. I apologize, Your Honor, but it is with respect to any sort of as I said, the FDCPA is any sort of misrepresentation, any false claim, any falsehood by the law firm makes them liable under the CPPA. And as I said, if you look to that case that I mentioned, Heinz v. Jenkins, which I've cited in my brief, in my opening brief as well. I think I may have cited it in the reply as well, but I think in the opening brief, it basically explained to the court exactly why law firms are also subject to, they're not immune from engaging in deceptive practices based on, just because they're a law firm. Their litigation conduct is subject to statutory debt collection laws. With respect to, and as I said, with respect to here, I think I cited to the court the Maryland case that says law firms are not, that you can't engage in deceptive practices with immunity because they're UDAP, Unfair Deceptive Acts and Practices Act. Their UDAP statute, also this challenge was made to them, and I also cite them. I believe it's the Andrews case, and the highest court in Maryland stated that no, just because you're a lawyer doesn't mean that you can engage in deceptive practices with impunity. Further, if a lawyer isn't allowed to do this, a creditor was to just say, "Hey, go ahead and make all these false claims. Litigate this case and make as many false claims as you want," and they're protected because the law firm is, immune. That's the whole point of the FDCPA being applicable to the law firms, because the creditor should not have the law firms be some sort of shield to the creditor, where the creditor can't make these false claims, but the law firms can. Because the law firms are engaging in debt collection. They're engaging in filing, and, if the law firm is filing a regular action, defending in a regular action or filing an action of breach of contract, or not breach of contract, but a contract, IP, intellectual property case or something along those lines, that's different. But this is a debt collection action, and they file thousands of these actions a year and receive thousands and thousands and thousands
At the
of
risk of
debt
dragging it
defaults.
out further, let me ask you, you surely can't be saying that a law firm would have absolute immunity. It would solely be in context of this statute somehow, right? Because if a law firm was filing frivolous and false claims, the attorneys and the firm would be subject to a variety of sanctions, malpractice claims, et cetera.
Well, this is the thing, Your Honor, and with respect to, as I said, I think I may have cited a quote to you, the like 70%, debt collection is a different animal. So that's why it applies only to debt collection type cases, not to regular cases between two entities and that kind of thing. And a law firm that primarily engages in debt collection, so that is a very specific area of of practice that is being.
Yeah, I've engaged in this
alleged.
practice before. I'm familiar with it.
Right.
And so what is the distinction here that the law firm has impunity? Is it that you believe the financially strapped or underrepresented individual would not file with the bar or with anyone else or seek any of these other potential remedies they would have if these firms were just lying regularly?
Well, with all due respect, Your Honor, they don't. There's not, and this happens all the time. This is not something unique to Ms. Bell, which is why this is class action and not just a single individual lawsuit. This happens all the time where debt collection law firms, all they do is debt collection, debt collection law. Debt collection law firms tend to file these cases, and they convert these judgments to default or draconian settlement agreements where the court, and it's typically against a pro se or a no-show, litigant. So they don't have, they're not able to, so there's no, report to the bar or any, because nobody knows about it, because it's sort of the silent group of folks who are not aware of their rights, who have no resources to actually advocate on their own behalf or hire an attorney or know how to hire an attorney. So this just goes by the wayside, but it happens all the time. This is not something unique to, this is why, as I said, why it's a class action and not an individual single lawsuit. And it's not,
There's no further questions. Would you like to conclude, counsel?
and I would respectfully ask that the decision below be reversed. Thank you so much.
Thank you, everyone, for your arguments and time today. Well, the case is submitted.
All rise.